Good afternoon, everyone. I think we are ready to start now. Leo, am I audible?
Yes, Jackie, you are.
Okay. Thanks.
Yes, you are.
Thank you. So again, good afternoon. My name is Jacqueline Kagume, and on behalf of the Institute of Economic Affairs, I'd like to welcome you all to IEA's 21st webinar of 2024. So we are very glad that you've taken your time to join us for this very important discussion. We all know today is the anniversary of the promulgation of the Constitution, and so we thought it would be befitting to have a discussion to reflect on where we've come from, some of the main lessons that we've learned over the period, just to reflect on that journey and see what given the trends, what we should expect going forward. So as you can see, the title of our discussion of our webinar today is Kenya's Constitution at 14. It's basically an assessment, a legal and economic assessment, and it will be made by my colleague Leo and myself. We both work at the Constitution Law and Economy Program of the IEA, and so we're very glad that you've joined us. Before we get started, the IEA is a public policy think tank. We work on economic policy research and work across five program areas. So we have a program on public finance management, on law and the economy, on economic regulation and competition policy, popular economics, futures and foresight, and international trade, actually six, sorry. So, and our mission is to just undertake public literacy and also informed decision-making through providing an evidence base from which informed policy discourse can be had and informed policy making can be undertaken. So in a nutshell, that's the IEA's work. So the Constitutional Law and Economy Program, where Leo and myself work, focus on analysis and supporting institutions created by Kenya's Constitution, analysis of their work, monitoring their progress, as well as just legal and economic analysis of various policy choices. So we'll go to today's presentation for purposes of the normal. Please, if you have any question as we make this presentation, as I've said, the presentation will be done by the two of us. Please note down any question that you have on the chat box here, but we'll also allow you later to ask whatever question you might have or make a comment, because I mean, this is a discussion that is very pertinent to everyone here. So we'd also like to hear some of your reflections, and we'll allow you to do that during the plenary. So in terms of our outline, I'll take just about 30 minutes for the first part of the presentation or less, and then hopefully, and then my colleague Leo will also do the same. So this is the outline of our presentation. We'll begin with just a look at, remember we're looking at Kenya's Constitution at 14. So we'll begin with a look at the role of constitutions in economic policy, just to sort of create a background of why we think this analysis is important, and especially for an institution like the IEA that is concerned primarily with economic policy. So looking at the role of constitutions in the place or in the context of economic policy. And then we will go to the second part, which is on PEA. Just broadly, there's a lot that can be said if we think about political economy analysis of Kenya's Constitution. So we cannot exhaust the subject. It would require a whole day. So I'll map broadly what was some of the underlying issues, powers, interests, political, economic, and social factors that led us to where we are, to formulation of Kenya's current constitution. Then I'll highlight some of the key outstanding issues in our current constitution. And then my colleague Leo will come in and discuss some specifics with regards to some of those outstanding issues. And then he will also discuss the economic liberties, and we'll conclude with the challenges and we'll have challenges and a conclusion. So in a nutshell, that's the summary of our presentation. So in terms of an outline. So going into the substantial part, as we reflect on Kenya's journey, 14 years past, we thought it would be useful to start with just understanding the role of constitutions in economic policy. And we summarized these roles into 5 key points, just to provide like a background. And the first one is that constitutions play an important role in limiting the extent of political powers, particularly by curbing the state's monopoly on violence. I think for those of you who have had any courses or undertaken some class on constitutional law, or had participated in discussions on constitutionalism, you understand what we mean by constitutions being put in place primarily, first of all, to limit or to constrain the state's monopoly on violence. And this is basically one of the fundamentals of constitutionalism. And so for purposes of our discussion today, this role is important for creating a market-oriented economy where the private sector is able to operate freely without undue interference from the state. So essentially, what our interpretation of this is that by placing checks on government authority, constitutions help to ensure that the leadership or basically do not arbitrarily use force or coercive measures to disrupt market operations. So this is the first role in terms of constitutions and economic policy. The second one that in our assessment was we know that constitutions create set of rules, the overarching framework for countries' laws and regulations and institutions. And for purposes of economic policy, this allow efficiency in the economy by reducing what we call transactional or operational costs. So what we mean here, again, is that by defining the framework and rules for market operations, then constitutions, including our own, are intended to reduce uncertainty and transactional costs associated with various economic processes. That's the second thing. Then the third thing is that they define economic freedoms. And again, here, what we mean is that most constitutions are intended to lay the groundwork for economic freedoms through entrenchment of under the Bill of Rights. So basically, for instance, by guaranteeing property rights, providing the guiding framework for contract enforcement, property ownership, that elaborates definition of economic liberties, including freedom to trade, association, and so on. This is intended to guarantee access to economic opportunities without undue restriction. So that's the third connection that we make. And then the fourth thing is we see that constitutions in general tend to shape government's economic role. And this is by outlining the extent to which the government is involved in economic activity or in the economy. And so we see, even in our own context, that the Constitution defines the fiscal powers and responsibilities, including for instance, the authority declaring or establishing the authority to raise revenue, that's authority to tax, the authority to spend. So demarcating very clearly how these processes should be done. So in this sense, the constitutions basically like provide a legal basis for market regulation, balancing this with economic freedoms and the need to provide public goods, essential public services, and so on. And they also address social welfare and redistribution policies. And this is, for instance, in our case, we know that our constitution guarantees access to basic social security. Most others do the same. So that's the fourth role. Then lastly, we see that constitutions promote long-term or define long-term economic performance. And what again we mean here is that we know that by establishing the basic principles that would promote the stability, macroeconomic stability and predictability, then constitutions in this way create a stable, predictable environment for economic activity and possibly or hopefully for long-term growth. So we know that again, by ensuring or by requiring for transparency in government action and accountability, this is intended to promote good economic governance. And also lastly, most constitutions are designed to allow for adaptability, to be able to adapt in different contexts and reform. This is through provision of amendments, how like stipulation of the mechanisms for amending the documents. So this is intended, or it's expected to, or it's cognizant of societies being required to adjust whatever policies, including economic policies, to respond to evolving context, evolving economic landscape and challenges. So in a nutshell, that's just beginning with placing the context of what's the role of constitutions in economic policy. As we have this discussion, also remember that we are thinking about, the discussion today is focused on our own constitution, but it's important to understand the basis broadly of what the relationship is or what constitutions are intended to do and how they inform economic policy. So that's the first thing. So we go next to look at the political economy very broadly, like the political economy analysis of Kenya's constitution. Today is the 14th anniversary. We have this document adopted in 2010, but what are the underlying factors that led us here? So remember, obviously, that what we mean by political economy analysis is basically us trying to understand or to map some of the powers, or mention some of the powers, the drivers, the institutions, some of the incentives that guide or that informed a certain decision to be undertaken, or so some of those underlying drivers underlying in our case here, the adoption of Kenya's constitution as is. So as I said earlier when I was doing the introduction, this can be defined very broadly, and we have very many issues that we've summarized in these next two slides, but I will just talk about it in a broad way. So, and most of you on this call were privy to the discussions, have been privy to the journey of the Constitution, so you understand what brought us here. So the first thing was obviously the unconstrained constitutional powers, thinking about the factors that led us here. And we know that before this current Constitution, Kenya's governance was largely characterized by unchecked constitutional powers, and most particularly within the executive branch. So there was a lack of effective checks and balances, and what this meant was that the incumbent or the persons in power could often make unilateral decisions without accountability, or with very limited accountability. So this centralization, the centralization of authority allowed for concentration of power in a very powerful executive, often leading to decisions that were not reflective of the general will of the people or the interest of the broader population. So this sort of absence or constraints of government powers created great impunity and was one of the largest prompts for the need for a more constrained constitutional power framework. So that is the first issue. And as I discuss this, you'll realize that most of these issues are connected. So that is the first on unconstrained constitutional powers. And then the second PA issue that we, from our assessment, we see was abuse of amendment power. We all know that under the previous constitutional dispensation, amendments could be undertaken very easily. The threshold was much lower, which allowed for the persons in power to basically manipulate the constitution to serve their interests. So these abuse, weaken institutional checks. So if a decision was required to facilitate whatever decision was required by the executive, it was very easy to amend the constitution. By the time we were adopting a new constitution, I don't remember the exact number of amendments that had been done, but most people have characterized that old constitution as being greatly there's a word I'm looking for a document that has been changed greatly and does not resemble what it was intended to be. I'll remember it, but yes, so it had undergone very many numerous amendments, leading to a document that was not intended to be what it was. So again, this was one of the factors that led Kenyans to want a new constitution. Then the other PE issue was linked again to the first thing I've spoken about, was an imperial presidency, which basically refers to that excessive powers, accumulation of powers within the office of the president. So the president wielded immense influence over the other branches of government, again linked to the issue of separation of powers that I'll talk about again later. So this imperial presidency wielded great power over the judiciary, the legislature, and so mostly overriding checks and balances. The president at the time could almost operate above the law, and so it undermined democratic governance and was again one of the things that drove the urgent need for constitutional reforms. The other issue, again linked to what I've already explained, is on abuse of executive and judicial authority. So this was very prevalent under the old constitutional order. So we know that the executive branch usually interfered or often interfered with judicial processes and outcomes. And this compromised the independence of the judiciary and diminished public confidence in Kenya's legal system. So the lack of that judicial independence, it was not clearly, the independence of the judiciary was not as, there were certain checks that were added with the current constitution. So that lack of independence in the previous order and the executive's overreach basically illustrated or necessitated the need for constitutional changes to resolve or to protect the judiciary's autonomy and basically to enhance a fair administration of justice. So that's the fourth. Then the other issue is on excesses of security services. And what we mean here as a PA issue is we know that previously security services, including the Kenya Police, the military, often operated with excessive force, and there was very limited oversight in the previous constitutional order. So the use of security or the police and the military was used to suppress dissenting voices, to intimidate political opponents, and obviously to enforce the will of the executive. So we know, or we saw widespread violations or and abuses of human rights, which obviously undermined public safety. And again, this was one of the main issues that drove Kenyans to want a different constitutional order. I know as we state this, we can think about whether, despite those reforms and checks being brought about by the current constitution, we can debate to what extent some of these issues have changed. But I think you can already begin to see some red flags of going off with regards to some of the underlying issues that we had in the previous constitutional order, and the same issues still reappearing currently. So that's another issue. Then we had problems of pretrial detention in terms of bail. And here we mean in terms of bail and bond. And here it means, what we mean is basically there was denial of bail and bond. There were significant concerns with regards to just that the fair administration of justice under the previous constitutional order was not guaranteed or was not entrenched as clearly and elaborately as it has been in the current constitution. So we all know about the Nyayo House detentions and the gross violation of human rights that basically accompanied the issues around pretrial detention. And then we had an ethical conduct of leadership, another PA issue. And what we mean here is basically leaders were, corruption was a greater, I don't know, I think it was a much greater problem. I say I don't know because we still have corruption as a big problem. We still have nepotism as a big problem, but they were still serious characteristics of the previous constitutional order that led the persons in leadership to enrich themselves and their allies at the expense of the public. So this was another PA issue. I think the problem persists despite us enacting a new constitution, but it was another major issue. Then we go next to, I said the PA section is, there were very many issues and I will not exhaustively cover all of them, but the other issue was still connected to what I've already talked about on the issues of pretrial detention. We connected to this is detention without trial. I think I have already sort of explained what that how this as a factor led to people wanting, the Kenyan citizenry wanting to grant themselves a document that speaks more elaborately on protection of these rights. So the arbitrary detention of political dissidents, activists, ordinary citizens, basically highlighted a lack of legal protections and abuse of state power. So it was, again, one of the main drivers of the requirement of a new constitution. And then another issue was fewer economic liberties, what we categorized of fewer rights. So many people discussing the 2010 constitution have obviously talk about the broad, the very elaborate stipulation or entrenchment of rights and economic liberties. So under the old order, citizens enjoyed fewer rights. So the rights that we see stated in detail with regards to property, freedom of association, expression, and so on, economic participation, the socioeconomic rights that are articulated as separately. I hope I'm still visible. My computer logged me out. I hope I'm still audible.
Yes.
Yeah. Okay, thanks. So the socioeconomic rights that the current constitution have elaborated greatly were not previously included. So it was another underlying factor. And then the other characteristic or the other underlying PA issue that we see was that citizens didn't have a say or the participation in terms of public affairs was not a guarantee. It was not. It was actually almost not possible. So before the current constitution, input into various public affairs, government decisions and actions. So the whole issue of public participation was not articulated or provided for in express terms as express terms as it is. We know the emphasis that the current constitution has placed on the need for the public's input into policy making and governance. So that exclusion from democratic processes was the other underlying issue why citizens decided that they would need a new constitutional order that basically ensures that governance processes are reflective of citizens' voices. So it should be seen as as an additional avenue of checks and balances, the whole aspect of public participation, because it ensures that in addition to having the different arms of governments check or having powers constrained according to the different branches of government, we also have citizens' voices checking the operations of all those institutions and having their input. So that was the other issue. And then another PA issue is on misuse of public finances. So we all are aware, most of us are aware of the rampant mismanagement of public finances that characterized the previous constitutional order. We still have this, again, obviously with currently, but this is despite a more elaborate public finance management framework that articulates principles of public finance management and that creates various institutions to ensure adequate oversight. So that public funds were diverted in many cases. You all know those grand corruption cases in the past. So it was another major driver for the need for a new constitution. Then lack of equity considerations in public affairs. So this one was a big one, obviously, because the very centralized government, that lack of devolution of power and services and resources led to certain places and certain communities, certain categories of people feeling or actually being explicitly excluded from public affairs. And so the marginalized groups, including even women, youth, persons with disabilities, as well as different ethnic minorities, they were excluded from decision-making in a great way. And that's why citizens thought that there would be need for a new constitutional order that expressly makes provision for certain protections for these categories of groups to advance equity, stipulates the national values as including equity, and just that consistent or repeat mention of or requirement of equity consideration in public affairs. So that was the other issue. Then another PA issue, I think I've also already mentioned this, was an ineffective judicial system. Again, this is linked to the question of separation of powers. You can look at this again in terms of the question of the imperial presidency or a very strong executive. And then now we have an ineffective judicial system that was widely perceived as being compromised. So issues of corruption, lack of independence, delayed justice, lack of or denied citizens access to fair and impartial processes was basically how most citizens would describe the judiciary or the judicial system in the previous constitutional order. So, and this again was linked to the manner in which, because the independence had to be reascertained or redefined with a new constitution, and independence could only be guaranteed through ensuring an independent process of appointments, where the persons or the personnel within the judiciary are not beholden to the executive, and also trying to guarantee that financial autonomy as well, through the requirement for establishment of a judiciary fund and so on. So there has been progress. We'll discuss that later, but that was an underlying factor. I think I've already talked about the failure in the doctrine of separation of powers, so I will not repeat this, but it was a great underlying political economy issue. Then we had the pre and post-colonial issues in distribution of factor endowments, and here we mean that is land. And so here, as a PA issue, what we mean is that we know that land distribution has always been a very contentious issue in Kenya, just even before during and even before the colonial period. So those even after independence, we had many inequalities that persisted with the governments that came post-independence. So there have been those historical injustices, and the governments were unable to sort of redistribute the question of, or address the question of land and redistributing it equitably. So the need to have an elaborate description of in terms of constitutional prescriptions on land and other endowments and resources was one of the reasons, or one of other underlying political economy factor that led the citizens to want to address this as part of the historical injustices and promote fair resource distribution. So that was the other issue. And then lastly, with regards to problems with ethnic entrenchment in public service, I think I've already alluded to this, but basically, Kenyans wanted a way to balance a definite way recognized by the Constitution that would balance representation or appointments in the public service. So we know that previously the leaders often favored individuals from certain ethnic groups. We had nepotism, tribalism, just basic unfair or unequal representation in government institutions. And so the need to state expressly the requirement to have diversity as in appointive bodies was something that Kenyans thought must be or should be entrenched in the Constitution, and was one of the reasons, again, as to why there was that emphasis to promote sort of merit-based appointments and ensure diversity. The extent to which this has been done, again, we can discuss, but the leaders are now obviously conscious of that requirement, and any person can actually challenge certain appointments. This has been done. We've seen certain appointments being challenged in court, and it's because of the new constitutional order. So, as I said earlier, there are many others underlying political economy issues that drove us to be where we are today. But in summary, those I will leave it at that. Then I will now go to what now we assess as some of the key outstanding things or highlights of the current constitution. So remember, so now we've talked about what drove us or what brought us here. And so now we look at what are some of the things that now this constitution does differently or elaborates in a way that we think is sort of outstanding under our current constitution. So the first thing is the declaration or the supremacy of the Constitution. So here we're saying that we know that constitution is usually the highest legal authority in a country. So it's the supreme law of the land. So in our own case, it obviously declares that the constitution is the supreme law of the land, and obviously any other law or regulation, be it domestic law or international, anything that is not in conformity with the constitution is declared a nullity. So basically, what this means is that all laws, all institutions, all individuals are bound by the principles, and there should be no, it's useful to safeguard, for the safeguarding of rights, to ensure that we do not have laws or institutions that contradict the constitution or anyone advancing their own interests that is different from what is guaranteed by the constitution. So it's useful even for not only for ensuring for the rule of law that ensuring that all persons are equal under the law, but also for protecting those fundamental freedoms. So we have that supremacy of the constitution. Then the issue of separation of powers. When I was discussing the underlying political economy analysis issues, obviously the running theme, or one of them, the major, if we were to summarize all those problems that I've talked about, one of the things that actually was to help address the main running issues under the previous constitutional order was just the need to strengthen or rearticulate the issue of separation of powers. So again, as I began, I talked about the need or the requirement for constitutions and the role of constitutions generally, and also in terms of economic policy. So that constraining of power to prevent an institution or one person or body from becoming too powerful is basically the essence of this issue of separation of powers. So the current constitution has done or been very progressive as we think about the 14-year again reflection. It's been very progressive in ensuring that we now have clear separation of powers. Well, at least better. I will not say fully. In theory, it's very clear that there should be very clear separation of powers. At times we have seen, and I know there would be questions about the overlaps between the executive and parliament, for instance, and that executive influence, particularly on parliament. The judiciary has done a little better. But we see that this constitution has now done a better job at ensuring that courts are responsible for interpreting laws in a way that is not influenced by external actors. And so that system of checks and balances has basically been an improvement from the previous constitutional order. We've seen the judiciary take many decisions or declare very many decisions, actions, laws as being unconstitutional, something that is a great departure from the previous constitutional order. And obviously this is facilitated by the current constitution. We know about I talked about a previous issue with the numerous amendments to the previous constitution. Under the current order, you can see the strength in Kenya's current constitutional order in how preventing that the numerous amendments, there has been attempts, we all know about the several attempts that there have been to reform the constitution, and the fact that some of those decisions were challenged in court were not successful. So even if an amendment would be done, and we're not saying that amendments are bad, some might actually even be necessary, but the process is obviously a little more constrained, just to ensure that we keep the constitution intact. I think the word I was looking for earlier was mutilated. The previous one was badly mutilated. So just to keep the current constitution in the basically as was intended by the framers, recognizing the needs for change, but also bound by the limits of the law. So that's the other outstanding issue on the issue of separation of powers. Then we go next. So the other issue that is spoken about, or we know has been a great has been very progressive of the current constitution is the current Bill of Rights. So a core part of any constitution or a central part of any constitution is guaranteeing fundamental rights and freedoms to all equally. We know constitutions are not intended to and cannot possibly exhaust the detail of every entitlement or right or action that must be undertaken, but that broad framing to guide the rest of the legislation, policy, and action, particularly by government, is very essential. So our current constitution, one of the outstanding things about it that we have seen has been that extensive provision of rights under Chapter 4, which obviously reflects our commitment to human dignity. In summary, we've highlighted some of the rights protected. We know about the right to life, freedom from torture, and some of these were added in the current constitution, a departure from the old, obviously reflecting those issues that I spoke about earlier. The right to a fair trial, the freedom of expression, the freedom of assembly, right to education, healthcare, housing, food, and water. So these are basically the rights and the socioeconomic rights that are provided for under Article 43. So in addition to all the other rights that are articulated in, let me give you a broad sections 26 to 51. So we've not highlighted everything here, but including labor relations, economic rights. I mean, I've talked about economic and social rights, rights to the environment, family, consumer rights, various rights related to access to justice. So that elaborate articulation of rights, the Bill of Rights has been progressive. We've had interpretation, various matters going to the courts for interpretation with regards to this. And just that progressive requirement for interpretation and provision of these rights has been one of the outstanding things in expanding the rights, human rights, and just basically the dignity of the person. So in our conclusion on this is we are basically saying that these rights, it's list, the rights are justiciable, meaning citizens, exactly what I've just said, that citizens can seek enforcement in court. And it's also part of the basis for Kenya's fiscal framework that is set out in Chapter 12. So one of the things that should inform the formulation of budgets, our fiscal policy, is ensuring or guaranteeing the state ensuring progressive realization of these rights should be one of the things that inform in great detail allocation of resources and as well as expenditure. So that is a summary of some of the outstanding things in the Constitution. I will stop here on this slide, and then I will now invite my colleague Leo to take us through the next section. Leo, you're welcome.
Yes, thank you so much, Jackie. So one of the things that you notice from the political economy rendition is that the problems that came out that really bothered people at that time became part of the solution. And that's why you see the flow and the logic behind the 2010 Constitution being the way it is. So one of the things was independence of the judiciary. And And that independence was a question of now the question to hire judges, the question to discipline judges, the question again to make administrative decisions from the judiciary. And then again, as you all know, the definition of independence in the judiciary is around resources. So Parliament, and that's why it created a pathway for the Constitution creates a pathway, a different pathway on how judiciary resources, judiciary is resourced. It creates different organs. So one of them being the Office of the CRJ that prepares the budgets and sends them to the National Assembly for deliberation. In the constitutional order, that would go again through the National Treasury. And then the Treasury would outbid the judiciary and allocate resources depending on how they would like to influence within that. So part of it was to take away the management of the judiciary away from that. Again, define the principle behind what would be considered justice. Again, for us, we are refreshing a good judicial system as a public good. It's non-excludable and it's also non-rival. And in essence, and that's the thing. So the Constitution added the issue of judicial oversight. Again, aside from giving a judiciary those powers, it gave the judiciary powers on judicial review and for them to seize. And that's why the High Court has powers to review any issue within the Republic that are limited jurisdiction to review issues aside from just determining conflicts between government and between people. And that has been something that stands out. Again, whether the judiciary has been efficient and has lived up to the constitutional, what was expected of the Constitution is something that for us to judge, and we see weaknesses in certain areas and strength in others. Another issue, again, fiscal decentralization. So the Constitution introduces, there is broad recognition in public economics and public choice economics that fiscal decentralization is a key way of ensuring effective public service delivery. And therefore you see the way the response through the Constitution. So people wanted certain services in the grassroots. Some of them include primary health care. That's why you see health being developed. Water, still a shared function, but part of that water service providers are now controlled by counties. You see all these other functions. Again, so that is not just creating autonomy, but also transferring financial responsibility, but also transferring that aspect of responsibility. Then again, it allows counties to set priorities. So, and that's why that fiscal decentralization and that complete demarcation of functions allows a broader role that not just on the revenue side, but also allows counties to create that sense of autonomy and allow counties to play into priorities. Because you will see from rural counties, that spatial difference in terms of poverty, in terms of urbanization, all these other factors have a bigger issue in actually what public services come up. Then the next issue is on public participation. Public participation is an important virtue, and in many different ways. So there's public participation, the one that most people know, which is Article 201. Public participation on all financial matters. And that one, for any financial matter, there is a requirement for public participation. And and then again, you see another requirement, Article 10. Article 10 spells out the question about what forms that public participation is one of the national values. And then, for example, in Article 132, the most powerful political player, the president, is required under Article 132 to report on the progress of values under Article 10. And then you see another aspect again of public participation, objects of devolution. They emphasize again that that citizen participation in exercise of devolved power, ensuring those voices are heard. Then you see another level of public service again, public participation again, in the values and principles of public service. Again, public participation in policy making related to public services, public service. And in public service, this is important because offices, the chapter under public service gives room on how offices are created under the Constitution. And for them to satisfy those constitutional thresholds, one of the things that there has to be a consultation on public service. And you've seen a very good example of a contest around this is the case on CAS. And that now, this principle allowed that proposal to be defeated in court. Then the other specific Article 118 makes it mandatory for Parliament to go through public service. And then 119 on petitions. Again, Article 257 on the amendment of the Constitution. So, like you see that public participation public participation as a principle that is woven entirely within the Constitution. So there are two problems that you see with this major outstanding thing. One is threshold. So, for example, the Finance Committee can sit in Nairobi to deliberate a finance bill. Now, is that meaningful public service participation? The other people will say it should be on a county by county basis. The other people will say that is inefficient. Counties should be clustered together to create zones so that people can those committees can sit in those areas. So that's still a challenge, and that's something that has not been fully done. There was a proposal for a public participation policy, and also a national legislation that would define public participation. Some counties have run away with the issue and have actually crafted public participation bills from within their specific counties. One of the biggest things, again, is PFM reforms. Parliament in the previous constitution was a small political player, especially Parliament that predates multi-party. However, in this constitution dispensation, Parliament has been given the powers of the past. And if you read 220, they determine form, timing, and content of budgets. And then Parliament actually has unlimited jurisdiction over players in the economic policy space, including the central bank and others. Again, and in the PFM reforms, again, one of the things that you see is they constrain the powers of the executive branch. And then there's a distinction. You see a clear distinction between what we call fiscal and monetary policy institutions. So they separate the central bank, Article 231, aside, and then there's a mention of the Ministry of Finance in related to national government public finance obligations. So like on the part of borrowing, they mention the Ministry of Finance. And then Article 225 creates another entity called the National Treasury. And what we have presently, merger is actually a merger of the National Treasury and Ministry of Finance. But if you read the Constitution keenly, it mentions the Ministry of Finance, even when they are doing budget consolidation, the Ministry of, on behalf of the executive branch, the Constitution mentions the Ministry of Finance, but it reaches the question on control of public money. The Constitution mentions National Treasury. So those are some of the things, and people ask this question: is National Treasury the National Treasury for the Republic, or the National Treasury for national government? So, and that's a bigger political economy debate that needs to happen. Again, provide a three-part way so now budgets are prepared. But the clerk for the National Assembly on behalf of Parliamentary Service Commission for the parliamentary arm of government, the parliament, and then the chief registrar of the judiciary on behalf of the CRJ, preparing the budgets in consultation with the JSC, and then again the cabinet secretary for finance on behalf of the national government. So like it delineated and actually allowed a pathway that all these three arms can present budgets directly to parliament without now executive branch convening that. And the idea was to give some independence. And then the other independent institutions, the Auditor General, the CRA, and the Controller Budget. Again, one of the things, the power of amendment process, it raised the threshold on the two parts. Now, one part being the parliamentary initiative, another one being the popular initiative. And for each, it actually required a referendum, for a national referendum for specific issues, including the term limits for the term of the office of the president, independence of the judiciary, national values, territory of Kenya, sovereignty of the people, all these other things, and devolved government, things that actually the drafters and the people of Kenya felt that this could be subject to abuse. You all remember in the Independence Constitution, the first thing after independence of Kenya was to change the structure of parliament. You remember the Independence Constitution had the Senate, but that one was done away. And then subsequently, the other amendments that were done to increase term limits, all these other things. And in essence, you see that. Again, the power of amendment process, one thing that you observe is that the Kenyan Constitution amendment process was designed to be deliberative. That what people call in the constitutional language, that constituent assemblies would come together and then you deliberate, and then in the end you end up with a document that has broad consensus. That has broad consensus. And the issue again stems from the political economy observation of how that amendment process was abused. And then we asked the institute, because we are the Institute of Economic Affairs, and one of the things that we really value is the issue of economic freedoms, economic liberties, because the primary purpose of this charter in the name of Constitution of Kenya 2010, and the purpose of all constitutions, especially in free market societies, is to advance economic liberties. And you see that. So, for example, Article 40 on property rights, it actually limits Parliament from even enacting a legislation that can inhibits the enjoyment of the right to property. So that's a very strong. You see, the Constitution takes a very strong posture on that. Consumer rights. You see fair administrative action. You see access to justice. You see the issues on equality, freedom of expression, freedom of association. You see on transparency, proper fiscal management. You see on predictable taxation. You see intergenerational equity. You see a lot of these principles that actually form the basis of enhancing economic freedoms. Then the next issue. Now, what are the challenges? One of the things that you see from the Constitution 2010 is that you see the previous arrangements of the Constitution of Kenya 1969 being in place. Some of them defer to a very strong executive. So like, while the functions of and powers and functions of the president have been severely constrained in the 2010 Constitution, parties still defer to the other presidential regime. You see PFM arrangements, public finance management systems, still deferring to the executive and using the other norms. So you hear, for example, people saying KRA is the taxman. It's not true. If you read the 2010 Constitution on imposition, Article 210 on imposition of tax, you see that no tax can be varied or imposed unless through a legislation. Effectively meaning that Parliament is a taxman and KRA is a tax administrator. And those are two different things. Deferring now to KRA as the taxman gives KRA a bigger impetus. And that's why you see KRA as a policy unit, KRA as a strong enforcement arm. If you read the Tax Procedures Act, KRA as a tax agent has been defined to have the same powers as a police officer. So you see, they misconstrue the Constitution. They think they see the Constitution differently. So those previous arrangements are some of the things that still change the purpose. So like on the swearing of judges, nothing in the Constitution says judges have to be sworn before a president, but you still see the same appointment. So, and that's the problem. Again, confusions. Kenya is in a presidential system, a full presidential system, and a full presidential system means that actually the elected representatives form the primary, are actually the opposition, who and we, by opposition here in Kenya, carries a different connotation, that to say opposition means the smallest party in parliament, and that's not true. The opposition in this constitutional dispensation is Parliament. The Parliament carries that bigger role of now checking the executive's agenda, checking executive's appointment, checking all those things that the executive does, including borrowing and the others. But when you read through the current system, members of Parliament on the majority side behave as part of the executive, actually like cabinet secretaries. And that is something that has diluted the strong separation of powers principle that Jackie spoke about. Again, a failure of independent officers, constitutional commissions to assert an operational and constitutional independence. You still see the constitutional commissions that still rely on and defer largely to the executive. The idea, and if you look, Kenya's constitution is different from most constitutions because there is effectively what we call a fourth arm of government, which is now these constitutional commissions. And they've been given very specific functions. But when you see the posture they've taken, and you see that problem. Again, another problem is the weaknesses in parliamentary oversight. The structure, the anticipation of that a parliament under presidential system would require certain methods, change of structure, certain bodies like Congressional Budget Office and many others to actually bring that body to bring that body to be more effective in tackling more problems in Kenya. But you essence see that Parliament remained the same, and that configuration did not change largely. They've tried to change Parliament, the institutional structure of Parliament by creating that parliamentary liaisons, by the training institute, all these other things. But in essence, largely in the end, the structure of Parliament has not evolved to meet those problems. Another thing is on the design, the House's design problem. Here, Kenya is a bicameral, but it's not a pure bicameral. And by bicameral, we mean that a parliament with two houses. And in Kenya, you'd expect that those two houses have to have the same powers, and so that they are able to iron out issues, especially. So for example, one of the things that articles we've written is on whether the Senate is able to protect the interest of counties in line with Article 96(1) of the Constitution of Kenya, but without determining fiscal policy aggregates, especially like the deficit, without determining the deficit. How are you going to protect the interest of counties without determining, because you'd expect that deficit, which forms part of the borrowing and is the first charge on revenues, affects county operations, because if that debt becomes unsustainable, it harms the problem of the counties. So that is one of the big challenges of this constitution. Without the two powers, the powers for the two houses should be actually the same or similar. So like if you see the American design, the House of Representatives largely discusses in terms of budget making process, the final agreed resolution between the two houses is discussed in the House, the final part before it goes to the president for assent. And then the Senate retains the role of approving all appointments in the whether it's for the executive branch or the judicial branch. But so there's a design problem, and that's why it has created that problem. Now, another thing is misapplication of fiscal and monetary policy powers. So I told you about the National Treasury in the previous constitutional. The Ministry of Finance then, even before 2003, was extremely powerful, not just on fiscal policy front, but also on the monetary, on also directing the the monetary policy institution, the Central Bank of Kenya, on what to do until the famous Joe Donde, the member of parliament for Game in 2003 introduced some of those reforms that actually allowed the central bank to claw back the Donde reforms, including creating an MPC, and also just allowing the central bank to determine monetary policy in a bigger essence, and move away from just being the financial regulator for banks. So that's the essence. So, but you see now that the National Treasury is determining politically on both sides of the stick what forms the fiscal policy, and in a way through informal processes determining how monetary policy should move, despite the fact that the Constitution only emphasizes one function, which is price stability. And now you'd expect the central bank and the central bank is not supposed to be under direction of the others. So like that fiscal dominance that you see now is part of that constitutional challenge that exists. And then the other institutional design issues, like some commissions should have not been full-time. So one of them being SRC. And we start to see these constitutional commissions coming up and actually clawing back. So for example, you see new terms such as remuneration order that changes completely how wages for public sector are done. And that forms a big problem. What to watch going forward? There are uninformed common narratives. One of them being Constitution of Kenya 2010 is expensive. There's an assessment that was done by a select committee led by the former Auditor General that showed the Constitution is not that it's not true. There's another one that says Constitution is a living document, and so should be amended on a regular basis without some serious concern. And then some of the things, there are fewer studies that show actually what kind of progress, what kind of institutional design problems that the provisions in the 2010 created. What are those perverse disincentives that it created? And that's why we're recommending that some of the things is to apply economic analysis of law tools, positive economic analysis, normative economic analysis, using now economic criteria such as Pareto efficiency to examine this at a closer level. Now, in conclusion, as I wind up, one of the things that you notice is that there are things that needs to be pushed further. One of them is meaningful public participation. And that meaningful public participation, and especially that is guided by evidence, requiring that, so Parliament, so one of the examples that I wanted to give, and this is something we've been discussing at the IEA, is Parliament has taken a volumetric approach in amending legislation. So it's more legislations. If you count the number of legislations that the last three parliaments have done, in terms of volume alone, it's immense. But it's not legislations that bring far-reaching benefit that allows that Pareto efficiency, that allows now that efficiency and social welfare, it's not that kind of legislation. Secondly, you see again, so a bigger part of the 2010 Constitution was the judicial oversight, and one of the features of the judicial system in Kenya is case backlogs. I know you must have all interacted with case backlogs. So you go to court now, you can't get a date, an hearing date this year. You might get an hearing date post June next year. So meaning if you have a constitutional arm, if there is your constitutional rights are being violated, it's difficult. And if you don't get that injunction or get that, it's very difficult. So that aspect of judicial oversight is a big issue. So there are legislations that have come forward, like the legislations on health, amongst others, that hearing needs to be fast-tracked so that people can be able to know the outcomes. You all know that the finance bills for 23 and also 24 for 23 are still in court. The Finance Act for 23 is still in court. That aspect, that issue of case backlogs has really affected that judicial oversight. And then again, the place of earmarks. A very good examples in playing this fiscal responsibility. A very good example. Some clever Kenyans crafted the CDF Act, and now it was again redrafted in form of the national government CDF, and then they earmarked 2.5% of all revenues. Obviously, if you tell an MP who is supposed to determine budgets and revenues, that 2.5% would be controlled by it would go to CDF. Obviously, there is a bigger incentive in bigger budgets. That member of parliament, and that's why that fiscal expansion in the last decade is a problem. You see it as that it played a big role in chapter 12 of the Constitution being violated. Again, another aspect is sanctions related to leadership and integrity. So there are too many things that the chapter 6 outlawed. One of them gifts, one of them corruption proceeds, all these other things. But we still see leaders violating those, but you don't see that direct sanction. And that direct sanction was supposed to come through courts or through these constitutional commissions, but it didn't. Then the other issues on parliament weaponizing budgets, these ones we've discussed more often. Judiciary deferring executive on law formulation. So you see, a judge goes, but people go before a court, a judge finds that constitutional protections have been violated, but again allows the executive to remedy that. So you wonder that, and gives them a timeline. They have 45 days, or they have 90 days, or 120 days. So that's still a big challenge, because it means the judiciary has not understood its role, and its role is to make that finding. Once that finding has been made, it's the executive to go back and start from afresh. It could even mean, so like they are predetermining the executive to go in a certain direction, and that in itself is not so. Deferring to the way judicial officers need to view actors, because government has monopoly of violence, and government is they can coerce, but they have that monopoly to now force somebody to do they need to be put together on the same pedestal, as rather than putting one on an higher pedestal. So putting the executive here in an higher pedestal, the state on an higher pedestal, and putting the individuals on it's not fair. That there's no fairness in that kind of a system, and that is something that needs to be called out, that judges need to treat citizens and the state fairly on the same level. And especially given the fact that, listen more to the citizens, because given the fact that the state has that monopoly of violence, and coercion. It's very important that. So, and then again, you've had senior leaders of branches of government saying that these branches of government are interdependent. It's not true. Actually, if you read the entire constitution, there's nowhere that mentions that these branches need to be interdependent. That independence and autonomy was for a function, so that that incentive incompatibility problem is not created, whereby that power is centralized under one person. Then we've spoken about the fourth arm, which is the Constitutional Commission's failure to assert the authority, and then again, NCGDF changing incentive structure in separation of powers. So that MPs started listening more to Treasury than listening to what Kenyans were saying. And that's why when we end up in a problem like debt distress as it is today, it's a problem of institutional design. It's not a problem that, because if members of this, there were studies as early as 2014 that the current fiscal crisis would come out, but members of parliament and through the agencies were not able to, because of there were bigger budgets. Those NCGDF budgets were growing, and it forms that part. So thank you so much. Looking forward to your questions. I end at this. Jackie.
Thank you. Yes, thanks a lot, Leo. Yes, so I think Leo has provided a good summary and conclusion. So no need to recap what the presentation was about. So at this point, we'd like to welcome your questions. I've been prompting you to send any questions on the chat box, but I haven't seen any. So maybe I should allow anyone, if you have a question that you'd like to ask orally, you could raise your hand. I see, yes. Just give me a second. Yes, so I see Ken. Ken's hand is up. Please unmute yourself.
Yes, thank you, Jackie and Leon, for that wonderful presentation. I'm just wondering, did the assessment look into this? Is it the 1/3 or 2/3 gender rule, and how then it impacts? Because I think it's been one of those conversations that we are, it's never ending. I like the fact that you picked out on the PFM Act. My personal feeling is that whereas the Constitution is quite clear with regards to issues around decentralization and fiscal decentralization, the PFM Act in its detail works against it. And I think part of the problems we are facing with the counties is as a result of some of that detail in the PFM Act. I don't know if you'd agree with me on that. Lastly, I like the bit around the play of words, Minister of Finance, National Treasury, with respect to the Constitution. And I think the CRA had picked up on this and suggest there was some quite robust conversations, I think, some time back. And perhaps maybe it could be the same with respect to where the Constitution talks about Parliament, National Assembly, Senate. Maybe the devil is the detail. Maybe if we go inside, perhaps some of these questions could be answered. Thank you.
Great, thanks a lot, Ken. Anyone else with a question or comments, additions, your own reflection about the Kenya's Constitution at 14? Would anyone else want to add to the discussion? Yes, I see Nabutola's comment. Wafula says, the Constitution is highly technical. It does not offer itself to be understood and therefore to be practiced. What about civic education? Okay. So that's his assessment, that the document is highly technical and doesn't offer itself to be understood. And what's the place of civic education? So I think as we wait for, I don't see any other hand. So Ken, to answer your first question, before Leo comes in, did we look at the 1/3 gender rule, the 2/3, whatever, 1/3, 2/3 gender rule? So yes, we may not have added it to on the challenges here when we were discussing, but it's one of the things that we've mentioned in several of previous discussions that we've had here, and it's one of actually Parliament's failures. I think in the challenges broadly, as we summarized the challenges that we've seen in implementation of this constitution, maybe we should have stated it more expressly. Amongst the failures that we have seen is the enactment of a law to ensure the full implementation of that 2/3 gender requirement. We all are aware of the history of that debate. There have been various bills, amendment bills that have been proposed to remedy the situation unsuccessfully. The former Chief Justice even issued an advisory to the president to dissolve parliament for that persistent breach to or lack of will to implement that, or rather to operationalize that provision. So that is a running challenge as we see it. It's one of the things that we attribute fully and directly to Parliament's failure. So yes, we are very aware or alive of that challenge. It's just that we may not have mentioned it here expressly. So I think on Wafula's question regarding as to whether the constitution is highly technical. So we have had this, I think this is also personal subject, not personal, but the technicalities of the constitution we have had in different forums or quarters, this being said. And I think even for us as the IENDers for the Law and Economy program, one of the things that we attempted to do is just begin a public literacy or expand public literacy of the document. The Constitution is a document. Is the interpretation of it. So it's one of the things that we intend to do, but also that role of civic education. If you look at the distribution of functions, there's a requirement for different institutions to actually expand civic education on all different matters, be it constitutional literacy, be it when it comes to policy choices and so on. So there's actually that requirement. So I think from what I'm hearing from you is that there's need for expanded civic education on constitutional literacy, or some of the things that we make assumptions about being an easy interpretation or an easy read. So yeah, that would be my comment on it. Leo, I'm sure you'd like to add on the PFM related question by Ken.
Yeah, so so that's why the question on so the reason why we've chosen a political economy, we have applied largely two tools. One, the political economy analysis, and secondly, we have economic analysis of law. And when we take the two, we consider strongly institutions as a set of rules, and then we consider now we look at incentives. What changes what? So on the issue of the national treasury, if you look at if you look, for example, at Article 221, it speaks about that the cabinet secretary for national finance, at least 2 months before the end of each financial year, the CS for responsible finance shall submit to the National Assembly estimates of revenue and expenditure for national government. But if you look at specifically on the 225, on the control of public money, it speaks about a different now National Treasury playing a part in control of public money. And they say that National Treasury can prescribe measures, including stopping funds to an entity when there is a material breach. And material breach in this case, for example, is getting something like adverse or disclaimer. So like for the county government of Nairobi, for example, should have been closed 3 years ago if 2 to 5 would have lived to the 2. So there could have been a specific now the National Treasury looking at the entire government because National Treasury's powers under 2 to 5 on the powers control of public money, it's referring to all entities. But if you look at the Chapter 12 framework on national government fiscal policy, it mentions specifically the Cabinet Secretary for Finance. Yes, so, and you see the reason, you would even see the reason why 2 to 5, the Cabinet Secretary for National Executive, for Finance for National Executive, and Cabinet National Treasury for the entire government, why such an institution would exist. So those are some of the things that we saw. On the issue of such ideas needs to get to mainstream so that even Parliament can interrogate, because those incentives are real. People ask, with all these reports that the Auditor General has provided, with all these material breaches and the powers and functions of National Treasury under 2 to 5, why is no action? Why is there no action? Because even before Parliament handles that issue, you'd expect there's an expectation that an institution that deals with that the same. But you see that political players matched the two. The finance function now being overseeing fiscal policy for national government and control of public money together. And even the way the institution of National Treasury is set up, they don't largely issue reports, for example, on what actions they've taken on the things that they've discovered are material breaches to related to public finance. So you'd see that problem is a large issue, and that's something that Parliament needs to pronounce itself on. On the other question about, on the other comment on PFM, the PFM legislation, yes, I agree. That one I agree 100%. That it assigns more powers to Cabinet Secretary for National Treasury, even when there are such powers are not provided for in the Constitution, and in a way that changes incentives. Because the question we should ask ourselves, if the Constitution has provided these certain outcomes or these certain roles and responsibilities, what happens when you what happens when you prepare legislation that changes incentives that could that are required to reach that outcome in the Constitution? So that's another big. So like we've used the economist perspective of now thinking through incentives, because that's a very strong indicator on public finance management and political power, how people capture political power, how they deploy it, and how they use it, because they want to advance certain agendas. And that's why we think incentives. And that's why when you get just to end, I want to quote the illustrious words of economist Milton Friedman, that actually to have a very effective system, you don't need good leaders. What you need is a system that makes bad leaders do good things. So like, because Milton had observed politicians for a very long time, and you notice that people change. What changes people is incentives. People want to live in penthouses. People want to fly private jets. People want their children to go to very good schools, and they are prepared to take any risks to make that happen. So it's not something, so you have to constrain those powers in a way that brings that person in to act in a better manner. But redefining the problem in another perspective actually is not, will not yield positive outcomes. So back to you, Jack.
Thank you. Thanks, Leo. Before we close, because we are past the time that we intended to be here, I'll give this last chance to anyone who would like to ask a question or contribute to the discussion. Anyone, you can raise your hand. I see one last question by Jairus on the chat box, but does anyone else have any comments? Question? Okay, so I do not see any hand or question. So we have one last question as we make our closing remarks. So Jairus asks, what's the status of the implementation of the Constitution? For instance, on the requirement for legislation that gives effect to certain constitutional provisions, are there areas that have been ignored? Yeah, then I think I see a comment by Emmanuel. Yeah, so I do not see that the final point by Leo is pertinent. We continue to believe that there's a savior waiting in the wings. Then Wafula, Aye, well done for offering this space. Elimuya Kumbafu is missing. Thanks for the comments. So Leo, maybe you can, as you give your closing remarks, you can respond to Jairus so that we wrap up.
Yeah, so the question by Jairus, the status on implementation, there are still other legislations, so like including the including the 1 on 2/3 gender rule that are still in pending. Our assessment took a different rubric, which is to ask if you are thinking about institutions. If you are thinking about institutions, what would you want to see? Because this is not a checklist. This is not like a box. So we want first, even before we start discussing about the other legislations, because politicians are keen, and I've emphasized that Kenya's parliament has taken a volumetric approach in the way they do legislations. In other places, so like, for example, I keep referring to the US or South African, the legislations are, people think about legislations in that those ones that actually are able to change issues and society and the society pivot the society in a better direction. But for us, we are keen on volume. So like, and you look at it from whether it's a finance bill, whether it's legislations that want to catalyze different sectors, from agriculture professionals to solar, to people who install solars, to HR professionals. So like, those are legislations that, if we start now looking at it, evaluating using economic analysis of law to look at whether they allow the society to gain that Pareto efficiency, they don't. So because they are just meant to to be more volumetric, like so that people are just seen to be working. But now the usefulness of that work, you even look at the way finance bill. So like excise taxes on financial transactions has been in the budget, has been an issue in the finance bill for the last 7 years. So it's changing from 5 to 10. You change from 10 to 20. You come from 10 to 15. So you see what kind of nonsense is that? Because you ask yourself that whether that spending, Parliament spending 44 billion shillings annually is something that really for them to end up with such kind of an outcome. So like you've seen, you are in public participation and you hear like a tax on sugar, on confectionery. We have one chocolate factory in Kenya, and that tax on confectionery, you're placing it on one. So you see that legislation is volumetric. You see, like, so we need to move away from looking at legislations that are volumetric to looking at whether that legislation in effect is meeting those constitutional. So that kind of assessment is required, whether to give those certain constitutional provisions, because mostly legislation is drafted in the way Parliament wants to see it. They already have a predetermined outcome, and that predetermined outcome not necessarily is what is in the Constitution. I've seen also some other comments from Emmanuel, whether, for example, in order to improve incentives, is it under which politicians operate? Sometimes it could be you create disincentive. So like there's a very powerful incentive for governors, the one on impeachment. Once you've been impeached, you stay out. You can't come back to office. For that, largely for mostly people end up getting impeached, never come back to politics. But if you look at what that incentive, that's powerful it has created an incentive. That powerful disincentive has done. It has created also another incentive for governors to be able to use World Development Fund and use other incentives to guide MCS away from that kind of oversight that the Constitution 2010 anticipated. So some of these things actually, it's creativity, Manuel, like looking at you look at the problem and say, if this impeachment clause in the Constitution is making governors use World Development Fund, probably we need to outlaw that World Development Fund. Like you think about how do we guide Nikama? It's like, to use the Kiswahili word of guiding ng'ombe. So like you are adding cows towards a certain direction. You need to think about how do you create those incentives for people to go in that direction. So thank you so much, and looking forward to future constitutional Katiba days, and given that more Kenyans paid an heavy price for this constitution and the promulgation, and given the fact that it was one of the supported by a larger share of voters in 2010, then I think this is one of those documents that we should see that future generations should see. This should see even more than 500 years. Thank you so much.
Thank you. Thanks, Leo, for that response. As we conclude, I think my response to you, Justus, would be the same, that the status of implementation of the Constitution should not be regarded only from the perspective of legislation enacted. So there's also the operation of different institutions, the operationalization of some of the main underlying principles, for instance, because we know under the fifth schedule may not have been exhaustive in terms of prescribing all legislation or all mechanisms that must be put in place to fully realize the dream or vision of the Constitution. So saying that we have fully achieved the spirit of the Constitution or fully implemented it obviously is not we cannot say 100%, and even in terms of legislation, any other legislation, the fifth schedule ends with saying any other legislation. There was that matrix that prescribed all legislation that must be enacted by the end of the first 5 years and by the end of CIC's term. So while most of it was enacted, we know that any other legislation also includes the things around 2/3 gender rule, and also the other mechanisms that I'm talking about, that all mechanisms that should be put in place to fully operationalize. So not fully, but in conclusion, we can say that we've had tremendous progress. I think there are still challenges. I will not go back to what our conclusions and summary was, but basically, there has been progress with its challenges, and there's still quite a bit to be done by Parliament and all other institutions that should remain vigilant to ensure the full implementation of the Constitution. So I've put my email address there because we have constitutions, simple, not simple, but these, I don't know I hope you can see it, these little booklets. Not simplified versions, but just small, easy to carry versions. So anyone who's interested in a copy, you can write to me or also admin@iekenya.or.ke. We have copies, and we can make arrangements for you to have a copy of this if you're interested. So that's it for this webinar. We thank you so much for those of you who stayed with us till the end. The IEA is a membership institution, so for those of you who'd be interested in joining and becoming our members, please reach out to our communications team. They'll assist you on joining and being our members and explain the benefits of membership. Please look out for further discussions. We do intend to expand these constitutional literacy discussions as a program. So look out for those. Then the presentation for today will be available immediately on IEA's website following this discussion. And then lastly, IEA has another webinar tomorrow on a different subject led by another program area. So if you have the time to join us in the morning, please do so. So again, on behalf of the IEA and on behalf of CLE, Leo and myself, we thank you very much. And we wish you a happy Constitution Anniversary Day and a good evening. Bye, everyone.
Bye-bye.